Hi, I'm Raksha Jare and my student ID is 1206504 In this video, I will be discussing about the case study of Barry and Angelo, who are the buyer and seller of the shop. And I will also provide some possibilities of an action for breach of contract for Barry. So let's begin. After analyzing the case study of you as Barry, I got to know that you are in a big trouble and you want to get rid of it. So, let me review your case and advise you. Here, you saw an advertisement of shop and you wants to buy shop, and you made a contract with Angelo, where Angelo gave you the statement of the information about this shop. Whereas before the contract, the shop owners say that there is a highly profitable, the shop is in a highly profitable, whereas the turnover of the sales is $20,000 per month. Whereas after the contract, you got to know that the company or the shop is only able to earn $30,000 per month. So also he gave the wrong or the false statement that there is no any competition, whereas there was store of fruits and vegetable nearby, so which means that there was a highly competition as well. So since he didn't provide you the true statement of the shop in the advertisement, so the shop is likely to have involved in breach of section 18 of the Australian consumer law, so where you can cancel the contract. So according to the contract, you can cancel the contract whenever you don't want to be in the contract, and you can also claim for the damages under the false misrepresentation. So the another is that there is an also involvement of implied undertaking, so where a finance company is reposes the delivery van and you didn't had any lease payment to the seller, so which means that the lease was default. According to the contract of sale, an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party not declared or known to the buyer before the contract is made. So in this case, the contract between you two can be voidable if the shop owner didn't pay for the lease amount, and also if there is no any declaration of the third party. So I also got your another case which is related to the quality, that is the acceptable quality of goods. In this case, you said or you paid $2,000 for lease amount, sorry, for the loader, and unfortunately the loader broke down, and in order to repair it, it cost more than the cost that you paid for the loader. So according to the section 19b under the Sale of Good Act of Australian Consumer Law, states that where goods are brought by the description from the buyer who deals in goods of that description, whether he or whether he be the manufacturer or not, there is an implied conditions that the goods shall be of the mercantile quality. So which means that it was his responsibility to provide you the quality goods. So according to the rule, you can also ask for the penalty that you have bear it. So with these advice, you can easily get rid of the contract, and you can go through the advice that I have given, and you can sue him, since the first, that is the true false misrepresentation that he has shown cannot be you can claim for it, but the later on was not, that it was not related to the false misrepresentation. So in this case, you can claim for the damages that you suffer. So go through the advices that I've advised, and you will definitely get out of it. So thank you.